Ladies and gentlemen, welcome back to another episode of the Shots Fired podcast. Super excited for this one. We've got Phil Downs back on the show and drove all the way up here to be in studio with us. And today, guys, we're going to be talking about the April 18th, 2020 shooting of Officer Jason Fletcher, who was recently arrested under the new California 835A penal code.
Guys, listen, this is a really interesting case. Fletcher is the first police officer in the state of California to be arrested under the new California use of force law under the 835A penal code section. This case, when it rolls out and it's all said and done, is really going to set precedent for the rest of California, how police officers operate and work and respond to calls for service. And this is going to push all the way across the country. This case is absolutely pivotal. And we are really excited because Phil Downs is here today to talk about that.
Yeah, guys, make sure you stay tuned for the full episode because you're not going to want to miss this. Phil is going to break this case down, and we're going to discuss how this case is going to impact law enforcement across the nation.
All right, before we bring Phil in studio, we want to talk about today's sponsor, GC Shield. Listen, this is a state-of-the-art, brand new shield that's out there, level 3 rated, and only weighs 21 pounds. If you work patrol in that capacity, it is absolutely necessary that you have a shield in your patrol car. And this company now offers that, available for you. Let's take a look and see what they offer.
When responding to active shooter situations where you can't wait for SWAT and every second counts, GC Patrol Shields got you covered. Half the weight of other shields, so they are easier to transport, retrieve, and deploy. Has an unrivaled ability to stop edge shots, absorb multiple rounds. GC Patrol Shields are lightweight for enhanced mobility and can easily be connected to create a shield wall or barricade. GC Patrol Shield. Strongest, lightest, most resilient.
All right, guys, if you want to get your hands on that shield, make sure you click the link in the description below, type in the code, and get your hands on one. If you guys want to test one out for your department, they will send one to you. Fill out the information. It's as easy as that. Like Mark said, every patrol car should have a shield in it. This thing is so lightweight. It's so maneuverable. Why wouldn't you want to get your hands on it?
All right, let's go get Phil.
Hey, for another shot fired.
Copy, additional shot fired.
Shot fired, shot fired. Shooting at us.
Suspect shooting an officer.
Down. He's at the base of the stairs. White t-shirt, white male.
Coming to you from Northern California.
Negative K, nothing further, just
This is the Shots Fired podcast.
Back on that town property case, Smoky 76.
With your hosts, Sergeant Kyle Schoberg, retired police officer Mark Redlich, and Deputy Billy. We are America's leading law enforcement resource for training and tactics from experts in the industry. Here are your hosts.
All right, guys. Phil, thank you so much for driving down here from the Bay Area to come up and be in the studio. Everyone loved the first episode that you were on with us, and we can't thank you enough for carving out some time coming up here. And we're excited to talk about this case because, you guys, this is pivotal. This is going to be huge across the entire nation at the conclusion of this case. So, Phil, for those that didn't see you on the first time you were on our show, can you give a little bit breakdown of who you are and what you do?
Yeah, sure. I mean, first, thanks for the invite back. I really enjoyed sitting down with you guys back at this symposium down in Irvine.
Yeah.
And so yeah, that was I hopefully your audience got a lot out of it. I know I did. I really enjoyed meeting with you guys, and to come back again is a super big treat.
Yeah.
So me in a nutshell is I'm an attorney. I practice law in California. The law firm I work at is out of South San Francisco. It's called Cholakian and Associates. We're a civil defense firm. And so the areas that we practice are mainly in the realm of personal injury defense. And then we have other types of defense cases, but always in civil court. So no criminal matters. And amongst the practice areas that we have, part of that is defense of public entities and police officers if they're sued for alleged civil rights violations. In that I'm a recent join to the firm. In my prior practice experience was mainly probably 90%, 10% distribution, 90% being civil rights defense of police officers. And of those cases, it was primarily, your Fourth Amendment variety. So allegations of excessive force. And that's a federal practice area. So I've had federal trial experience. I've been practicing since about 2015, and this is what I do. And of recently, I've done a lot more kind of getting out in front of different agencies. Since about 2019, I've been teaching both under post-approved curriculum and then also kind of my own curriculum from a legal update standpoint, and specifically 835A, which for those outside of the state of California who are listening or watching this, is the penal code section that essentially gives police officers their authority to act under color of authority, to include the authority to use force. In California, the mantra is very familiar. It's your officers are granted authority by the state to use force to effect arrest, prevent escape, and overcome resistance. So that statute, which I know we're going to talk about today, I wanted to get into it the last episode because I had just been doing a talk at the symposium about it.
We ran out of time.
Yeah, well, the church group was showing up.
Yeah,
so
we did get kicked out. Yeah, we got kicked out.
We got kicked out for Jesus, which is okay.
Forgot about that.
Yeah, and so that statute was recently amended by an assembly bill, and the application of that statute is as we start to see, and sort of we being the law enforcement litigation community, as we start to see various district attorneys in different counties applying that statute to instances where officers have used force, and there's a question of whether the officers violated their authority under 835A, and in some cases, in one in particular, we're going to talk about with even we're going to talk about the San Leandro shooting back in 2020. That has resulted in an indictment for manslaughter, and so that trial is yet to be set. And I think everyone who's interested in both policing as a profession, and if you are keen on paying attention to the evolution of policing from a reform and legislative standpoint, that's definitely a case that you want to watch. And to see how it turns out. So that's a little bit about what I do and what I'm here to talk about tonight, and hopefully we'll have some good info to go through for everybody.
Yeah, and just so everybody's clear, we will walk you guys through this incident that took place on April 18th of 2020. And essentially what happened was Officer Fletcher of the San Leandro Police Department responded to a call for service of a theft at Walmart. He and another officer were both dispatched. And I think what we want people to get out of this episode or this podcast is just the evolution of law and, the restrictions on, police officers nowadays and what we can and can't do. And when this new law in California came into place, I think we all kind of glossed over it. No fault of anybody. I think even you said,
I had it wrong.
Yeah, right.
Yeah.
I think we all did.
Yeah.
And there is a lot of cops out there now listening to this right now who have it wrong, who don't understand the new law. And I understand that a lot of you are listening to this, not in California, probably scratching your head saying, why should you listen to this? Because it's California. And I'm here to tell you guys, listen to this episode, because even though this is a California law, this is going to be a nationwide precedent.
Yeah, you could look at it as like by analogy, what I was just saying it's the canary in the coal mine kind of a thing. So, and we were talking just before, starting to do this, this concept called the Overton window. And I'm not the expert to give a full breakdown of what the Overton window is, but my understanding of it is something along the lines of when when the contours of a debate shift radically to expand into new territory, that tends to permanently alter the landscape of the discussion, the discourse. And as an example, you could pick, like let's say the size of the federal government's budget, right? That from an Overton window standpoint, the budget has grown. If you were to compare it to, say, what the federal government was spending, decades ago, it's like, well, it's much larger now. We're talking about much larger figures, several trillions of dollars, and that seems to be normalized to talk about numbers of that size. And whereas before it would have been radically unthinkable to have that as part of the conversation. So in terms of what we're seeing from a litigation side, I put 835A as part of the what would be referred to as police reform legislation, and that certainly was the motivation for 835A to be amended by Assembly Bill 392, and there have been other pieces of legislation that have followed on the heels of 835A. And I think it's important from a national standpoint to pay attention to what the California legislature is experimenting with. And I think experiment is a fair term. It's not meant to be a pejorative. It's part of the beauty of our federal system is the states get a chance to experiment with what works and also find out what doesn't work. And California has in the past in other areas of let's say environmental regulation or other areas of the law, California, where it's decided to take a lead and deviate from the status quo, other states have actually followed, and then now that ushers in a permanent shift in the conversation. And so what we can look at, in order to frame the conversation about 835A, and I think to frame it properly, you have to look at this from the standpoint of the state, in this instance, California, has decided to, and this is not only my view, but I think this is the fair reading of the statute. The state has decided to further restrict its traditional police powers, and by establishing stricter standards for when an officer can use certain types of force. And by doing that, it would, if it were properly communicated, and we can get into that later on about how this was rolled out, and the perhaps the lack of a comprehensive training plan to really drive home the point that the standard is different now. Yep. And here's why it's different, and it's so different that I'd say it's a fair characterization that the law disfavors speed. And there's much more emphasis now on pre-incident decision-making, tactical planning,
100%,
and resource application, using alternatives, whether those are techniques or whether those are employing additional resources to a scene, that necessarily means that calls are going to take longer to resolve. Situations might become more attenuated over time, and it's not going to turn over as quickly as it does. I think that change is something that has to be talked about openly at agencies. And another change we should be looking at in the future, and it's already started in California. It's inevitable in my mind that it'll spread, but when I look at sort of how this statute will eventually play out, as all laws tend to do, once the law is in place, there's a lengthy process, usually through litigation. In this case, it would be criminal litigation against police officers. You start to get clarity from the courts about the meaning and application of the terms of the law. We're at the beginning stages of that. So let's say over the next 10 years where I see this going, it would not surprise me if in my lifetime, in the next decade, police agencies in the state of California do away with the the organizational approach to, or maybe approach is the wrong word, but they would do away with having a solo officer in a vehicle on patrol.
Yeah, we were actually talking about that as a result of this case.
Yeah, and that the police departments would move more toward investigations, very heavy resource allocation to investigations, and then more employment of either at least paired officers, a partner in your patrol vehicle with you, if not paired units, so that you have maybe a 4-man or 4-woman team that would be employable, at a particular given situation. Because again, I think the way this law is written is it disfavors speed. So,
you talked about that, the window and how it starts to widen. I remember when I first started in a couple of years on, 2010, it was normal to get dispatched to a call with multiple officers, but you were the closest. You would go to it. You'd try to handle it quickly by yourself when it was really dangerous. Mm-hmm. And then you tell everyone else, hey, code 4, you don't have to come anymore. I handled it. So you really kind of half-ass that call to jam to another call.
Yeah.
And now what you're talking about with this new law in the window, it's really getting to the point where you've got to take way more time. And I like that you mentioned about the riding 2 officers in a car. Mm. I always rode 1 officer in a car most of the time. And now I would argue I would want a partner with me to prevent that incident from happening.
Yeah.
And it almost seems really smart to do that. Definitely.
And I think there's a lot that you bring up there, and we can, I think it's readily apparent in this particular instance we're going to talk about, the San Leandro shooting, because at least it's been reported from what I read in the local media. I don't know when earlier this year. It might have been before spring, but there was a motion that Officer Fletcher, so he's formerly of San Leandro Police Department. His attorney, Mike Raines, who's well known in the state of California for defense of police officers, super capable, well experienced trial attorney. Raines' office brought a motion to dismiss the manslaughter charges, and it was denied. And what was reported in the media, and I haven't read the transcript, so I don't have any inside info on this, but the news media at least glommed on to some of the comments by the judge who heard the motion, and the pull quotes were, "I don't understand the rush. What was the rush? Why didn't he just wait for, he being Officer Fletcher, why didn't he just wait for his cover?" And so I think I don't know if it would be helpful for you guys. We can break down the factual sequence of it.
Okay. We will. We definitely will. Let's break it down. Let's talk about what happened, because again, for those of you that don't know, this did result in a deadly shooting by former Officer Fletcher. And you know what? Before we get into that, I don't think it's a bad idea that we do not wait for our partners and come up with game planning and all that stuff. But now it's almost like you have to. Yeah. Like there is no wiggle room.
Well, and so that's a good point. It's not, from a common sense standpoint,
it's not a bad thing.
It's not a bad thing to say, hold on one second, let's take a knee. Right. I call it take a knee to sip water.
Yeah.
Right. And before I became an attorney, I was in the Marines, and I was an infantry platoon commander, and that was a sort of a mantra that we had. And it actually paid some dividends in combat. Is before you get committed to something, figure out, just get your wits about you for a second. Mm-hmm. There's nothing wrong with taking that extra half a step to say, all right, do I have everything that I need? What am I actually headed into right now? What are my contingencies? And just being sure of that plan beforehand. But the change in the law, because the law has changed, it makes that pre-tactical, call it pre-tactical
planning or
pre-incident plan. It gives it legal significance now.
Yeah.
And a failure to do that step, a failure to consider the situation in light of the particular circumstances, or a failure to use available techniques and resources that would be safe and feasible to an objectively reasonable officer. That's language directly from the statute.
Yep.
a failure to do those two things could cause you
some serious consequences.
Some really serious consequences, some really serious issues. And you can debate, at the symposium in Irvine, I had a discussion with a senior district attorney. I won't name the county. And he just said, I have a difference of opinion as to how this, like, I don't look at this statute as being different. And I said, well, that's nice. I mean, you have that prerogative. There is such a thing as prosecutorial discretion, but when do you retire?
Yeah, because in this case,
in a couple of years,
this case is telling you that it is different.
Yeah, and the next wave or the next generation of whoever the men and women are who are going to staff district attorneys' offices, there's not any guarantee that they're going to pick up the mantle of the old guard and continue to look at things through the old paradigm. So, I think briefly, and I understand, you guys can are going to be able to provide, the video to your viewers so they can clue in and watch it for themselves.
We will.
I think one of the more informative versions of the video I saw, that I think YouTube says is not safe for me to watch anymore. So I can't, I can't actually get it. And I wish I had downloaded it, but it had played the dispatch, of the 911 call.
Go ahead, sir.
Hey, I got a shoplifter subject. He's in a store right now. I mean, he's trying to leave the store, but he has a bat. He has a bat with him, and he has it in the air, and he's threatening to hit an associate with it.
Okay. And did he actually leave the store yet?
No, he didn't leave the store yet.
So what you have in San Leandro, and for those of you who aren't familiar with the area, in the Bay Area of California, your two big cities to the west and east are San Francisco and Oakland, respectively. And then on the east side, in Oakland, falls within Alameda County. There's a number of smaller but mid-sized cities that are all kind of grouped together. And so San Leandro is one of those. And it just, imagine your typical Walmart shopping center, right? In an area that's gets a lot of busy foot traffic, and there's plenty of folks around, and you have a call from a Walmart employee reporting a male subject shoplifting. Mm-hmm. The dispatch call goes on to reveal that the reporting party describes, and he's describing this guy Stephen Taylor, who's the decedent. And he's saying he's got a baseball bat in his hand. He's waving it. He confirms for dispatch. Dispatch asks him if he's waving it in a threatening manner. He confirms that he's waving it in a threatening manner. But he's not leaving the store. He's staying in the store. And customers are trying to help him. And he seems to have, there seems to be an argument going on with some of the customers. And then I don't know if further information was relayed to dispatch, and I also don't know, and this is important for all of us to kind of be patient, and eventually the evidence would come out at trial, but how much of that was actually relayed to Officer Fletcher, who's dispatched to respond. Another thing, and I don't mean to throw this in right now because it could lead to a rabbit hole tangent, but I think it's a little bit overlooked, and I'm speculating, to be fair, but it's something to discuss as to whether, Stephen Taylor was setting up a, suicide by cop type situation, because it has all of the hallmark fingerprints of a suicide by cop situation where, and we know that he didn't leave the store because the confrontation occurs in the store with the officer. Mm-hmm. And if he's a shoplifter, well, shoplifters tend to leave.
Yeah.
They don't tend to stay.
Right.
And so, and this isn't something that's unique to California. I think there are people out there in this country who are troubled enough to create a situation where they will use a police officer to assist them in ending their life.
Sure.
And so I'm not saying that was Stephen Taylor's mindset at the time, but for whatever reason, after this 911 call was made, he never left the store. Officer Fletcher arrives on scene and with cover en route, He's the first one into the store. Body camera footage is available. There's also bystander witness footage that's available. And I would recommend, folks look at the video where it cues together the bystander footage with the officer's body camera.
There you go.
You don't drop that. Bust in, nigga. Get bust in. Bust in, bro.
Oh my God, you is so stupid.
Back up. Hey, back up. Hey.
Get the bat down. Drop the bat, man. Drop the bat. Drop the bat. Shot fired, shot medical. Sit down.
And Officer Fletcher, when he enters the store, he goes to Stephen Taylor. Mr. Taylor's there. He's kind of twirling the bat in his hand for a moment. He becomes aware of the officer. There's a moment of recognition, and the confrontation sort of is set. The game is set. And you can see in the bystander video that Officer Fletcher reaches and touches the bat, which Stephen Taylor's holding up over his head. And at the same time, the officer has his firearm drawn. Stephen Taylor doesn't go along with the commands to just give me the bat. He doesn't give himself up. And he does what you can, you can watch the video, speaks for itself, but there's a dynamic movement that he makes to step backwards. And now there's distance between him and the officer. And at that point, Officer Fletcher shoots him with a taser in one hand, has the firearm in the other.
Right. Yep. And that's something important to point out is he now has a taser in one hand and a firearm in the other hand.
Yeah.
Which is a problem in and of itself.
Yeah. And the taser's doing that thing that's proverbially written in reports as not having the desired effect.
Right.
Which in plain English terms is it's not working.
It didn't work.
It didn't work. The suspect is withstanding the taser.
Right.
And there's a moment where Stephen Taylor changes the position of how he's holding the bat. And I know you guys are going to play the video for the audience so they'll see it. But once that position of the bat changes and then there's a step forward that he makes, the officer fires a single shot, strikes him. Taylor walks backwards, drops the bat. He's mortally wounded and collapses to the floor. And I think before he collapses to the floor, the cover officer, who has now arrived, fires his taser. And again, not to do another tangent, but there's a pending civil rights lawsuit. I don't think it's been settled yet, and because from what I had read, the city announced that they were going to defend it against the city of San Leandro and the officers, both officers. And when I first saw the video of the shooting, my question, and this shows you that I did not understand the significance of the changes made to A35A. All right, I'll just say that. Because when I first saw it, I was like, well, looking at this from the civil rights standpoint, that's probably a case that you would have to either settle or try. There's a very, very remote chance, if any, that an attorney would be able to get a dismissal before trial, either usually what's called a motion for summary judgment. The reason for that is because there's too many facts that are in dispute based on the framework under the Fourth Amendment and the jury instructions in the Ninth Circuit, which is 9.25, the civil model jury instructions. And if you look at case law that deals with similar factual situations, there's a question of whether that was excessive force, that a judge can't determine as a matter of law in favor of the officer. It has to go to a jury to get figured out. And I even think that there would be enough of a dispute to where qualified immunity would not be granted. right? And that was my initial take. It's like, well, you probably have to try that case. I remember specifically texting with a friend of mine who had sent me the video where I said, that's not manslaughter. I typed that out.
And that's after the DA had filed.
No, this is before charges
before they charged him.
Yeah.
Okay.
So before when the shooting happened, 835A was in effect.
Right.
AB 392, which is the Assembly bill that amended the statute,
had been in play.
And
only for what? For about a year at that time, if that.
I don't even know did it go into effect in 2019 or did it go into effect in January 1 of 2020?
Right. Either way, it was either
very recent.
It was very recent.
And I had read the statute a couple times, and what I did, and this was my error when I read it, is I read it as, how do I fit this square peg into the round hole that I'm familiar with? Okay, because prior to this amendment, 835A and the California standard for officer use of force was a direct parallel mirror of the Fourth Amendment standard. Mm-hmm. And so I read 835A as amended. I read it in a way where I tried to make sense of it to fit it within the Fourth Amendment framework. And I thought I had it figured out. And I also, relied on sources that I trust, and what I was seeing being what I was seeing and reading and hearing out of the law enforcement, defense side of litigation was that this was the same law, just different words.
And that's how we were sold as law enforcement when this first came out was, hey, not a lot changed. It's just worded different, but everything means the same. So,
yeah. And
which we mentioned.
Yeah. And when you're an attorney, you get paid to make words mean different things.
Mm-hmm.
Right?
Yeah. So that's a good way of putting it.
So I read it and was like, I could figure out a way to make this still be the same. Problem was when I approached it from that standpoint, I'd never asked myself, what if I'm wrong? Okay. And I think when you try to, and this is true, even if, you're getting into, you're starting to get an interest in case authority and you read an opinion, like, I don't know if you guys, if we've talked about the community caretaker doctrine before, but
we have on prior episodes we have.
Yeah. So there's a case, Ovieda, and it's a California case, and it dealt with the community caretaker doctrine. And I distinctly remember reading Ovieda and thinking, yeah, that makes sense, because this was a case where, the officers didn't have the factual basis to argue there was an exigency. And a lot of my peers in law enforcement, I shouldn't say my peers because I'm not in law enforcement, a lot of my former clients and my friends would ask me, is community caretaker dead? And it's like, well, no, it's not dead. Well, why would you say that? They were reading it from the standpoint based on the sources they were getting through a certain lens where they made the assumption ahead of time that something was different, something had changed. Similar thing here, just in the opposite direction. There was this assumption that nothing had changed, that it was the same. Yeah. And so we read it to apply that way. So anyway, what made me realize that I was incorrect was watching the press conference that District Attorney O'Malley gave to the news media to announce the charges.
Well, let's real quick
go for it.
Before you talk about that.
Yeah.
I'll just cover really quick who this officer is.
Oh yeah, sure.
Just so we know. So it's Jason Fletcher. At the time of this, in April of 2020, he's 49 years old, has close to 29 years of experience in law enforcement. He initially started in Berkeley, then lateraled over to Fairfield PD, worked at Fairfield PD for a little bit, and then spent the last 14 years at San Leandro PD. So he's a well-experienced police officer, entire career.
But to your point, his background had over 2 decades, almost 3 decades worth of police experience.
Yeah.
Right.
And I think when we look at, having watched the video a lot, there isn't anything that immediately stands out where it's like, oh man,
Oh yeah.
Excessive.
That's definitely a crime that you just committed. There, you can always look at any video of any incident like that and say, shoulda, coulda, woulda. You know, to quote Jim Harbaugh after the Niners lost to the Ravens in the Super Bowl, he said, shoulda, coulda, woulda is undefeated always. And it's like, okay, fair enough. You know, should have, could have, and would have. If you wanted to take that approach to it, you could say, well, could this have gone differently? Should this have gone differently? Would it have gone differently if this, and this had happened? Sure. You can always look at that. And I think it's important to view things sometimes from that perspective to try to gain a lesson, to learn. But there was nothing immediately about what happened where I would say, oh man, that's the guy just committed a felony. But and I didn't mean to cut you off because I don't know if you had more to do on his background.
No, I was just just painting the picture so everybody knows
how many years, who he is and how many years.
Yeah.
And then if you want to
so right, in other words, he's not fresh off of FTO.
No, he's not.
Yeah.
Now, when we watched this video and we just showed the viewers, where do you think he went wrong? Why did charges get brought against him?
So if I put my Nancy O'Malley hat on, and I think from her perspective, there's a couple things, and this is where you have to get into you have to have the statute out to read along, and where to start. Usually when you read something, you read from top to bottom. I think it's inappropriate to read 835A top to bottom. There's a certain way to navigate what I view as a cobweb statute. It's hyperlinked within itself. There's just not links for you to click on to tell you that things are connected.
Right.
So you have to start to figure out kind of how to navigate the thing. So what I did after I watched the press conference was I picked up the statute and I started at the end. And the reason why I started at the end is because the last 3 subparagraphs of subsection E are the definitions. And in the definitions, there are 3 things that are redefined in California. Deadly force is redefined. Imminent threat is defined. Probably for the first time, it's statutorily codified. And then the totality of the circumstances is redefined. Just taking that last one, the totality of the circumstances is defined essentially as, facts and circumstances known to the officer at the time. Mm-hmm. But it also includes, and the statute explicitly mentions this, it also includes the officer's conduct leading up to the use of deadly force.
Yeah.
And so then with that statute, with that part of the definition in mind, you then look at, I'd say the next thing you would look at is subsection D, which deals with retreat, the idea of retreat. Now, traditional old 835A language was just very simple, that an officer does not have a duty to retreat. You don't have a duty to desist in the face of resistance. The amended language goes one step further and it says, okay, you don't have a duty to retreat, but for purposes of this subsection, retreat does not mean tactically reposition or other de-escalation tactics. All right. So that's a really important change. It's like I call it a passive mandate. And I kind of ignored it at first read, right? It's kind of like, if you wanted to, like you ask your wife, you want to go to Vegas, like, hey, babe, me and the guys, my buddy's getting married. We're going to go to Vegas. You're cool with that, right? And rather than give you a yes or no answer, she says, something along the lines of, if that's what you think a good husband does, or, it's like, well, if that's what you think a responsible father does, to leave your kids at home while you go, for a weekend of debauchery.
So that's it. You scratch your head and you go,
it's like,
all right, see you in a couple of days, babe.
Well, I wasn't going to go, but if you're saying that's what a good husband does, I
have to.
So it's like, you don't have to retreat, but retreat doesn't mean de-escalation or tactical repositioning. So then you're like, all right, what are you driving at? What's the point? Well, then you look at the change to this only when necessary language. And for those who are familiar with the statute, this is the point where it's like, all right, is only when necessary different than objectively reasonable? And here's what I mean. So the statute writes in two paragraphs. In subparagraph B, it says that an officer may use objectively reasonable force to effect arrest, prevent escape, and overcome resistance. That's traditional language. We're all familiar with that. That's old 835A. The very next paragraph, subparagraph C, says, notwithstanding subparagraph B. Notwithstanding is a fancy word for despite what I just said. Notwithstanding subparagraph B, an officer may use deadly force only when necessary, okay, based on the totality of the circumstances, in any of the two following situations. Then it lists two categories of examples. When you're reading the statute, you've got to kind of pause there and figure out, well, where is it that necessary is defined? Because in the definitions, we've already talked about totality of the circumstances now includes the officer's conduct leading up to the scene. Leading up to the use of deadly force. Imminent threat, which is now mentioned I'll put a pin in that. We'll come back to it. Deadly force, which has been redefined in California. That sub 1 definition, deadly force, is any force. Like, dwell on that word any for a moment. It's any force which creates a substantial risk of serious bodily injury or death, not limited to the discharge of a firearm. How do you digest that? Right? It means that any force means any force. So that's as broad a language as you can get. And then it says not limited to the discharge of a firearm. So now deadly force is no longer just the gun. It's a lot of other things. If they create a substantial risk of serious bodily injury, that's the lowest part of the threshold that you would establish. So then you'd say, all right, what counts as serious bodily injury? You guys know that.
Yeah.
Right? Okay. It's similar to GBI. It's similar to great bodily injury. Okay. So sutures, extensive suturing, loss of consciousness, fractures.
I think there even has to be a certain amount of sutures.
There does, but not many.
Yeah.
Not many. Okay. So then, or if you're like a deformity, the wound results in a deformity, like a scarring or something that doesn't heal right. Okay. So then you look at that, and then you'd have to go identify the lowest possible threshold for what serious bodily injury means. And what I did was I went into the California appellate courts, published cases, looking at appellate challenges from criminal defendants who were challenging the sufficiency of the evidence at trial as to the enhancement on their crime for serious bodily injury. So there's a serious bodily injury enhancement that's given to some underlying felony. And then you look at what evidence was sufficient enough at the appellate level to be SBI. And what you find is, not that much is required. Mm-hmm. 2 stitches in an eyebrow, a broken nose that doesn't heal correctly. Yeah. Right. Those things are SBI. So just alone in just reading the definitions, you know that this law is after something it's radically changing the concept of what deadly force is. It's changed the concept of what counts as the totality of the circumstances. And then it outlines what an imminent threat is, which is a multi-factor test, all the factors of which have to be present in order to constitute an imminent threat. Once you've got those definitions, then you can get into the rest of the statute. So listening to the district attorney in Alameda announce the manslaughter charge against Jason Fletcher, the points that she dwelled on, or kind of what she listed out, was in the first instance that it wasn't necessary.
Yeah. So I actually have it pulled up here what she says, and it says that the legislature declare the officer shall use other available resources and techniques if reasonable, safe, and feasible to an objectively reasonable officer.
Yes. And
Officer Fletcher failed to do so.
Okay, so that's the allegation.
Yes.
Right? Now, what do you know? What part of the statute she's reading from for that proposition? That's in the legislative intent.
Yep.
It's subparagraph A, subparagraph 2. All right. Sub A, sub 2. The second half of that operative paragraph says that in determining whether deadly force is necessary.
Yeah.
Okay.
So what
an officer? Go ahead.
At what point does that statute that she's citing, when does that go into effect with this officer?
From the beginning.
So getting dispatched the call.
Because force is because the totality of the circumstances includes the officer's conduct leading up to the use of deadly force by definition. So that means the window of the totality begins from the moment the officer is dispatched.
So knowing his cover was coming, right?
Correct.
That'd be one fact.
Should have waited.
Wasn't imminent that he needed to be there right now.
Right.
Is what that boils down to.
Or also the argument would be, and if I was wearing my district attorney hat on this and I was intent on prosecuting this, what I would say was, based on the decisions that you made, did you eliminate certain options and alternatives?
Yeah, and it clearly says that here. So at the very end of it, I mean, it says, I believe Officer Fletcher's actions, coupled with his failure to attempt other de-escalation options, rendered his use of deadly force unreasonable and a violation of Penal Code Section 192A, which is voluntary manslaughter.
Yeah.
So,
and that part that you talked about there, his failure to attempt de-escalation, that's that subparagraph D of the statute, which is the redefinition of retreat, to say that retreat does not include tactical repositioning or other de-escalation tactics. You don't have to retreat, but retreat doesn't include these two things. Mm-hmm. And in determining whether deadly force is necessary, officers shall do two things. One is you shall evaluate the situation in the light of the particular circumstances. It's a close paraphrase. And then the second duty is to use other available resources and techniques if reasonably safe and feasible to an objectively reasonable officer.
Yeah.
So it's like, when does that, to your question, when does that duty kick in? Well, based on the totality of the circumstances, it kicks in at the very beginning. And that's, I think that what's overlooked on this, and once I watched her
press conference
and I reread the statute and I read it back to top down, bottom up, and then I started to try to figure out how these various subsections interrelate with one another, because if you apply a statute, you have to apply each part as part of a whole. Okay. And it was a light bulb moment where I was like, oh wait, no, I see what she did. I don't agree with it.
Right.
But I see what she did.
But what's interesting, but also scary, is cops are going to calls like this
all the time.
Every day.
And they may not result in a shooting, but they're going to calls still today in the circumstances in a way.
Well, so you're gonna if you look, 835A is a lot to digest, and I think we could fairly talk about it for 4 hours, and we'd still have questions,
absolutely,
especially as to its application.
Mm-hmm.
If you don't know the rules of the game, how are you going to play? 835A is the rule of the game.
Yeah, it is the rule.
And it used to be an exact match to the Fourth Amendment.
Right.
And so objective reasonableness was the standard.
Right.
And that's an easier rule to understand. I don't even think departments and agencies do a good enough job of teaching what objective reasonableness actually is. Setting that aside for a moment, this is way different.
Yeah.
Way different. And to your point, officers go to these calls all the time, every day, throughout the state.
And he probably had the mindset that it was not going to turn out like this.
Absolutely.
Of course not.
And then it does.
Yeah.
So for those, I
think that's true, because if you infer from his actions, he does attempt de-escalation.
He does.
He does. He puts his hand, he touches the guy. The bat. He doesn't go right in there and thump him in the face. And he's talking to him. Did it work? No, it didn't. At that point now, you could, and this is how I first looked at it. At that point, I'd say, all right, well now you're in the horns of the dilemma. And so maybe if you go back a couple steps, and if you had a chance to retry it, what would you do differently so that you're not placed in a position where you have one of two options: get hit in the head with a baseball bat or shoot and kill the suspect? Because those are not optimal options.
No.
Right. So that's how that was the only criticism I ever had of it, was just looking at it. And I say that with all humility and due respect to the profession of police officers, because I haven't ever had to do that job. So me and what I did with my Marines in Ramadi, Iraq, under our rules of engagement in 2004, way different than what police officers have to abide by in the United States of America. Mm-hmm. Police officers have a much harder job. So eventually you have to put your hands on this person to take them into custody. And you'd like to do that without getting yourself seriously hurt or killed. And you'd like to do it without having to seriously hurt or kill the suspect. And if the great incalculable in all this is the other person, like, you don't know the extent to which they're willing to fight to not go with what you're asking.
Yeah.
And so, so that was when I first saw that, my criticism was just like, man, now you've kind of limited yourself once you're there.
Yeah. I think he owned the scenario when he responded by himself. And I think what it comes down to is knowing he had partners en route. And I think, in the statement was, I think his cover officer was like less than 2 minutes away or even a minute away or something.
But if he had also been told by dispatch that there was, a male subject in this Walmart waving the bat about in a threatening manner in an argument with a customer, then I could see there being some urgency to, I should get in here. And this is the great quandary for police officers, is like, you have a moral imperative, because people who become police officers, for the most part, in my experience, tend to do so because they want to help their communities.
Right.
And you have to have, at least inherently within you, some kind of a bias for action to do the job. So part of that bias for action and the way we've structured our society is we want police officers to take action to prevent, or I'd say to protect the vulnerable from predation. Stop bad people from doing bad things to good people. And so, yes, we want police officers to respond. We want them to go in. I mean, we saw the national outcry after the Uvalde, Texas shooting when officers did not go in.
Yeah.
It's like, we don't want that to happen. We don't want officers to hesitate and not be confident in what they're doing. At the same time, you have to balance that with having a wary eye on the state's exercise of authority. And police officers are granted, pretty significant authority. And as a fan of limited government, I like having well-defined contours and limitations on the state's ability to exercise its authority. And that includes police officers. So you got to find this balance. And my worry is with and it could depend county to county, how district attorneys choose to apply in their prosecutorial discretion, how they choose to apply 835A. But my worry is that the balance is going to be a little bit upset. And I'm not sure that is the right kind of experiment, or that experiment would yield very good results for society. And I think this is not a scientific opinion, because I think it'd be very difficult to capture this data. But my sense is, having paid attention to this sort of stuff my entire adult life, and most especially since I began practicing, is there is a bit of a change in law enforcement where officers are saying, I just don't know, so I'm not going to. Mm-hmm. And they start to become less active, and that will embolden elements of society who don't want to abide by laws.
Yeah, and I think we're seeing that right now.
Yeah, and the consequence to that is, like, bad things will happen to good people.
Yeah.
Now, you can say, well, that's not a very wise public policy, and I would agree, it's probably not a wise public policy, but you have to let it play out. And in the meantime, officers really need to do their homework on 835A to know what exactly is the limit on their authority. You got to know these rules, because if you don't, you're only accidentally correct, which means you're like one slip up away from possibly facing felony prosecution.
Yeah.
So, so at least in the civil
let that
side,
sink in.
You can lose your life in this job, but now it's more likely that you could lose your freedom.
Yeah, and your livelihood. It affects your family's future. It affects your children if you have them, and also it's like, look, even if Jason Fletcher is acquitted, or I think the most likely outcome is going to be a hung jury. So it's not really a win. The prosecution can always refile.
Right.
And drag it out again. But it's like how much that guy's life has changed, and the impact this has had on him. And it's like you wouldn't, even if he is acquitted and vindicated, it's like, was it, the 3 years that it will take to figure that out, his life's been upside down. And then at the same time, you have a family of Stephen Taylor that is grieving, and you have loss of life. And if you could look at that and say, well, was that preventable? Could we have done it differently if we had followed, which is the DA's argument, right? If you had done what the statute had told you to do, this wouldn't have happened. Right. It's like, well, then, we want to make sure we fix that, because we don't want the exercise of government authority to go without some sort of challenge, right? So it's a very delicate balance. But
so with what you know about this case, your experience, what could you say to help cops stay safer right now?
Speed is disfavored.
Yeah, and I would agree with that. I agree with that. And Mark, with your background also in SWAT, excuse me, I think speed never really gets you anywhere. I never think that using speed to your advantage is ever a good thing. I mean, in the tactical world and in our background, when you show up to these high complexity calls that are rapidly even evolving, I think even being able to slow down and just kind of digest what you have. And you had just mentioned it when you were in the Marine Corps, like finding out like what exactly do we have and like what resources do we need to tackle this problem in front of us. But just rushing into anything, I don't think is ever a good thing.
Right.
And I think the biggest takeaway for cops in this particular case is, we do have resources available to us, and you have to start utilizing them.
Yeah.
I mean, it is now in the rule book. And I know there's a lot of cops out there that are like, not even cops, but just people that are thinking about becoming police officers. And we get asked this all the time on this podcast is, it's a dilemma for people now to even want to be police officers. And we're having a hard time in the industry finding good quality applicants to be police officers, because people are like, why would I want to do that? Yeah. Why would I want to subject myself to either being thrown in jail or killed? Which is a valid question.
Yeah. Well, and it's not an advantageous way to set up society. We don't want to discourage people who would otherwise be willing to perform a vital function in public service.
And I think to your point, I think the answer to that question is just know the rules of the game that you're playing, and I think you're fine.
Yeah.
And that just comes down to good, solid training. We say it all the time, but like, that's why we do this podcast, is to like bring, people like you on who are experts in this, in the industry, who can, train people to just maybe think a little differently, maybe read up on some case law, understand the rules that you're playing.
So I would say this, this is the follow-up part to your question. So the first, like I said, speed is disfavored, but then how do you want to set yourself up for success? Because it's not just enough to say, all right, I'm going to go slower now. So now what? Take a moment and just look at this from the standpoint of, you're in a profession, okay? I'm in a profession. I'm an attorney. I have to read case law. I have to practice my profession, or else it atrophies. Police officers are no different. Yeah. You're in a profession. You have to practice your profession, or else it atrophies. One of the imperatives in your practice as a law enforcement officer, I would say, is understanding the limits on the state's authority to exercise its power. So if I know where the limits are, I'm less likely to trip over them, either inadvertently, or I'm more apt to recognize a situation where I'm going to be put in a very tough spot and I will not have good options available to me. So I'm going to try to figure out a contingency before I commit myself to this, because I know where the boundary limit is. And if I put myself in a spot where I don't, here's an example, putting yourself in the horns of the dilemma. And this is something that YouTube does let me watch this video. So, it's a San Jose, incident. This occurred during the aftermath of the George Floyd death and some of the summer protests that were happening across the country. There's a sideshow, so some reckless driving during a protest, and police go to stop the sideshow driver, and she takes off, runs over a pedestrian, nearly kills this gal, and then runs over an officer, hurts him pretty bad, a motor unit, and the officers give chase. They lose her for a bit. They find her again. The chase is back on. The chase ends up being drawn into a dead-end alleyway, and it's a single motor officer.
Oh, yeah. I just watched this, actually.
Yeah, okay, so that's the definition of the horns of the dilemma. What are your choices? And it's not the officer's fault necessarily, because that's not what I'm implying. It's more of like, the reason why the officer's there in that position is because of the suspect and what the suspect's doing.
Yeah, she put him there.
Yeah. But then once you're there, it's like it's too late to get out.
Right.
You don't have good options. And that ended up in a non-fatal shooting, but still not an ideal situation.
Right.
There's that line in Inglourious Bastards. The problem with fighting in the basement, right?
Yeah.
You're fighting in the basement.
Yeah.
Right. What's the problem with following a suspect into a dead-end alley? You followed a suspect into a dead-end alley. Yeah. So that's one of those things where it's like, hey, we're going. The situation's rapidly evolving, and it's very easy to without even being negligent. It's very easy to all of a sudden find yourself in a position where it's like, hey, this is not a good spot. And so, my hat's off to police officers, because it's not an enviable position. Number one, with kind of the discourse nowadays politically, but then also it's actually really freaking hard to do it, and to do it right. And the fact that, if you looked at the aggregate statistics, most interactions with members of the public don't end in any force whatsoever.
Yeah.
And not just most, I mean, like over 90%.
Yeah, it's high.
And so it's a pretty good success rate. And I'd say that the reason why, police reform or police use of force is such a hot topic, let's say, is because it's that visible, very tangible exercise of state authority, and it gets people a certain way. So I'd say, speed is disfavored, and to know the rules, start with a collection of just like 2 or 3 cases out of the Ninth Circuit. All right. And I'll give them to you. And this is over the course of 20 years. All right. Start with Deorle v. Rutherford. Deorle v. Rutherford. It's a 2001 case. Just start with that. It's a 5150 call. Ends in a beanbag to an eyeball. Knocks the guy's eyeball out, fractures the skull. There's an appeal taken from a summary judgment at the trial court, and the Ninth Circuit opinion really sets out, I think, in a way, it sets out the contours of objective reasonableness in a way that's easy to understand. It might be frustrating to read it, but it's easy to understand. After you read Deorle, read Voss v. City of Newport Beach. Voss is VOS, City of Newport Beach. That was a fatal shooting where the officers were given qualified immunity on the shooting, but the Americans with Disabilities Act claim was remanded back to the trial court for a jury to resolve. And that was a case where you had a young man high either on methamphetamine or bath salts, some sort of synthetic amphetamine, and he stabs a 7-Eleven clerk. There's the store is cleared out. There's a standoff. He comes running out of the store with what appears to be a large knife in his hand, and he's fatally shot at the threshold. And it's an interesting case to read because that's really the first time the Ninth Circuit talks about de-escalation. And they talk about de-escalation from the context of the ADA, Americans with Disabilities Act. So read that one. And then I would say you could read either Orn v. City of Tacoma, or Monson v. City of Murrieta. Orne is a slow-speed vehicle shooting. Monson is a high-speed vehicle shooting. And those are just good cases to read because it talks about what immediate threat means. Okay? So just those are 3 easy cases. Just do Diorel, Voss, and Monson, let's say. And then as you read those cases cite to an entire body of case law in the Ninth Circuit. So if you want to pursue what's the court talking about when they establish this as the rule, they cite to these other cases, like Nahad v. Browder or something like that. Okay, I can click on that, I can read it, and that's going to give me further information about where the contours are from a constitutional standpoint about excessive force. With California changing 835A, amending 835A, it's too recent to have any sort of definitive case law on it. The only case that I know of, and I could be wrong, but the only published case from a California appellate court that deals with the new 835A from a civil standpoint is, and the name escapes me for the plaintiff, but you guys remember the Stockton bank robbery back in 2016 or something like that? Okay. The gal who escaped from the bank robbers who took her hostage in a van, led police on a high-speed chase, and there's AK-47s and thousands of rounds shot and all. It was mayhem, right? This running gunfight on the freeways and surface streets in Stockton. She ends up flinging herself out of the car to get out, and she brought suit against the police officers and the agency, saying that you're the reason why I had to do this.
Wow, I actually didn't know that.
Yeah, and that was the summary judgment was given in favor of the officers, so her suit was dismissed. But that's the only case I know of that really took the new 835A framework, and that's an easy one for the court to deal with because you have a running gunfight. That's an obvious imminent threat.
Right.
Okay, so you really don't have a lot of case law to guide you as to what 835A means. So I'd say the only option you're left with is you got to read the statute, and how to read the statute is just as important as plain reading the statute. And so I would suggest that officers begin with the definitions. And I know that sounds weird because that's at the end of the statute, but I have a lot of close friends in Napa County and the sheriff's office there, and they did that after I recommended it, and they said it absolutely helped with reading the statute, because once you have the definitions in mind, you pick up on the words in this. It sounds obvious. It's why don't you just read it top to bottom? You pick it up. It's well, yeah, but after you get through, there's 5 paragraphs of legislative intent. By the time you're through the 5th paragraph and you're like, I don't even know what I'm exactly reading right now. And not all officers are trained attorneys. So even for an attorney to read that, you're like, let me go back to the beginning and read it again. And then by the time you're done with that and you get to the very end, you read the definitions, it's not obvious that you have to go back then and find where the defined terms are and reread those subsections to figure out what exactly it is they're driving at. So if you read the definitions first, you'll pick up on the defined terms in the other subsections, and that'll just clue you in. And then you can go, after you get the definitions, I'd say read subparagraph D, which talks about the redefinition of retreat. Even though it's not written as a definition, it redefines what retreat means because it says what retreat is not. Once you have that, I would do the first 2 paragraphs in the intent, which is the one is the broadest statement of legislative intent, the reason for passing the statute. And that's important because when courts go to eventually hammer out what exactly the legislature meant in this statute, they start with the intent paragraphs. Then the second intent paragraph is what defines necessary.
Yeah.
Once you have that, then you go into sub B and sub C, which is the you could call it the guts of the statute. And for California officers who might be listening or watching, if you take anything away from 835A, you have to memorize and just absolutely immerse yourself in subsection E, subsection 2, which is the definition of an imminent threat. An imminent threat in California is defined as someone who has the present ability, opportunity, and apparent intent to immediately cause serious bodily injury or death.
Yeah.
Not merely the fear of future harm. So fear of future harm alone is not sufficient to constitute an imminent threat, and the statute explicitly calls this out. So not merely the fear of future harm, no matter how great the harm or how likely it is that the harm will result, but is one from appearances, this is how the statute reads, is one from appearances must be instantly confronted and addressed. If you can live, breathe, and eat that rubric, the imminent threat rubric, you'll do well, because that will put you in the proper frame of mind.
Yeah.
A lot of the questions I get are, when can I use? So, for example, deadly force being redefined. You guys do a lot of. You guys have had canine officers before on your podcast.
Yep.
Right?
No, I am a prior canine handler.
And you're a prior canine.
Yeah.
All right. So the dog from here on out is deadly force. You release a dog, does that create a substantial risk of serious bodily injury?
Yeah.
Yeah, it does. Now you can argue what substantial risk mean. Okay, well, good luck. Because if you want to test that theory out, you have to test it out in the confines of a criminal court, which means you need someone to be the guinea pig as the defendant.
I don't think anybody wants to sign up to do that.
No, definitely not. And if you look at if you have an understanding generally of California law, because there isn't a thing that's defined independently as substantial risk, but you look at what courts would do to define that is they would look at parallel aspects of the law dealing with foreseeability, and you could have as an initial judicial interpretation something along the lines of substantial risks means that it's likely.
Yeah.
It's foreseeable, because if a dog is released, let's just say you guys would do this if there's a commercial burglary, and you call out to whoever's on the inside.
Right.
There's no response. So either one of two things is going to happen. Well, three things. 10-8, we're done.
Mm-hmm.
You go in and go room to room or part to part, or you send the dog. Mm-hmm. All right. If the dog finds someone inside, what is there a substantial risk of?
Getting bit.
A dog bite will require what?
Yeah, sutures. Sometimes, yeah.
Serious bodily injury. Yeah. And there's no, you can't argue that it's not.
Yeah.
You can't, because there's controlling case authority on point with, I forget the penal code section, but you guys know if someone has a dangerous animal.
No.
And there's a penal code section where if you have a dangerous animal and the dangerous animal gets loose and bites someone, right? There's criminal liability on that. But the requirement is that there be serious bodily injury. And so there's case authority, good case authority in California talking about how, something as simple as 4 sutures on a dog bite is sufficient enough to constitute serious bodily injury. So then you look at that from a canine officer standpoint, and it's like, every time I release this dog, am I using deadly force? And I'd say if you give the statute the plain meaning of its terms, yes. That doesn't mean you can't release the dog. It just means that there has to be an imminent threat, which is why I go back to sub E sub 2, that imminent threat rubric. You have to know it. And it's not a question of when can I use the dog. It's a question of what facts do you have and what facts would you need.
Sure. Before using the dog.
Yeah.
That's a great point.
Yeah. So it's like, go back to that commercial burg example. You've called out and no one's responded, and it's like, well, what do we do now? We're at the crossroads. We have to make a decision. It's like, well, if you send the dog, you have to ask yourself, do I have an imminent threat? And if I don't even know that there's someone on the other end of this door inside this building, then I'm really going to have a hard time arguing that there's an imminent threat. There's a fear of a future imminent threat, but that's the fear of future harm. And that in and of itself is not sufficient to constitute an imminent threat. So then you ask yourself, what do I do? Well, we're just going to walk away from it? We're just going to walk away from commercial burglaries always because we can't send the dog in because we don't have an imminent threat. It's like, well, I'm not saying that, but are there reasonably safe and feasible alternatives to an objectively reasonable officer that can be employed? Because that's what the statute's asking you to do. And so is that a question for department leadership? Do we need to start employing more, I don't know, drones, remote control robots? Can we get an eyeball in this building before we send in the dog? Is there one extra step we can do? Those questions should be asked, because I think the statute is establishing an incentive to ask them. Does that make sense?
This whole 835A thing is so in depth. It blows my mind, and it's been around for almost 3 years.
Yeah.
And I guarantee every officer that I've talked to, my closest friends, don't know most of this.
No. And I've done like we were down at the symposium together, and that's a group, CalFIA, California Force Instructors Association. People who went to that actually have a keen interest in use of force and use of force law. And I did the eyeball test.
Yeah.
When I asked
how big their eyeballs got.
Who here read the statute? And I got some kind of like 50% hands, which means they probably glanced at it and they were like, what does our attorney say? What does the LDF attorney say? Oh, he says it's the same. Okay, fine. I'll stop reading. And then there were people with the face like, please don't fucking call on me.
And you did.
Yeah, I did. Yeah. And you find out what happens, and it's like, guys,
that's the rules of the game.
Guys, that's the rules of the game. That's equivalent. That is equivalent to not qualifying with your firearm. It's like, that's a skill that's going to atrophy. You would never think, oh, I don't need to practice with this weapon ever. I just need to carry it. That's all. It's like, no, you wouldn't do that. That would be derelict. You'd be crazy to go out there and not maintain your perishable skills.
Yeah.
That would be nuts. So if you don't know 835A and it's not as easy as the old one. The old one was easy. It was a parallel to the Fourth Amendment, which is objective reasonableness is a lot simpler to get across to folks. And even then, it's not really well taught, but it's at least easier than this freaking cobweb of a thing with like layers to it. And you got, if you don't know it, I'll just say this.
This is a good preview for the next time we have you on. This is a good preview.
Yeah. So if you don't know it, this is to the California folks, and then look, nationwide, stand by.
It's coming for sure.
Just wait.
It's coming.
And if you don't know, oh my God, look, it's already happening in Illinois. Okay.
There's other states that have adopted 835A.
Yes, there's other states.
They mirror each other.
There's other states that are doing this.
Yeah.
Okay. So, and you can look at it and say, well, yeah, that's California and that's Illinois, and it'll never happen in Wyoming.
No.
Probably true. It'll never happen in Wyoming, but there's like 1 million people that live in Wyoming, and unless everyone's going to move there, then it'll find its way there too. Okay?
Yeah.
But
it's coming everywhere.
But let's save this.
Yeah.
When
definitely.
you come back.
Yeah. So I would just say, look, guys, if you don't know it, at least acknowledge that
that's your job. You need to know that.
You're playing a game. You don't know the rules. And if you don't know the rules, you are really putting yourself in a position that's dangerous.
It's almost grossly negligent, honestly.
It's really, it's
death or the loss of your freedom.
Yeah.
Yeah, for sure.
Yeah.
That's crazy.
So,
yeah, it's interesting. And we could talk all night about this, but
we definitely could.
Well, listen, we'll wrap this up. And I know you guys are listening. It's a lot to digest. Listen, do the research on it. Okay. Watch this case closely and see what the outcome of it is. It's going to be interesting. Phil, I mean, honestly, thanks for coming up here and I mean, shoot, listening to you and even the last time we were with you, like I learned a lot. I know Mark does. We always leave here like scratching our head, like, damn, like even being around you the first 10 minutes that you're here, I'm like, I learned something.
Yeah.
So I really do appreciate it.
I thanks for having me. And like I said, this is a real treat. And, this isn't about me. Even it's
not about us, right? It's just about educating and like we all just want to be better.
Yeah, it's the education standpoint, and the way to do that is to do part of that is doing what we're doing right now, which is just have a conversation about this.
Yeah,
right. From the standpoint of an open mind, just assume I might not have the answer right. Let me look at this, and you can talk with your peers about it, and like you said, man, it's your job.
Yeah.
You got to know. You
have to know.
So I really enjoyed coming up here tonight, guys. I really appreciate it. So thanks.
Thank you. And this podcast, we're all about training. Like that's the whole point, is to try and keep people informed. We have a class coming up, right, Kyle, in January of next year. Well, in 2 months in Elk Grove, California. And we have additional ones that are going to be scheduled out. So check out fieldsurvivaltraining.com and get signed up for that class in Elk Grove.
Yeah, it's going to be good. Until next time, Phil, we'll have to have you back on again for sure.
Yeah, I appreciate it, guys.
Yeah, thank
hey,
you.
quick shout out to 1097 Coffee. You guys go check them out. It's law enforcement owned. We want to support them. So until next time, guys, hey, be safe. If you guys have any questions, make sure you hit us up. Happy to answer any questions that you guys have. And we don't know them, we'll ask our networking of friends and get the answers for you. So, hey, be safe out there, and we'll catch you guys on the next one. Thank you.
Yeah.
Thanks very much.